All right, I'm Jacob Hornberger, president of the Future of Freedom Foundation, and welcome back to our online weekly conference, Restoring Our Civil Liberties. Last week, we started out with Tom Palmer, who's with the Cato Institute and the Atlas Network. And those of you that watched the presentation, I think will verify that it would be impossible to find somebody better than Tom Palmer to give the introductory lecture on this series. His knowledge of history is just unparalleled, and he just gave a fantastic talk, and we're going to be posting that tomorrow, probably in the morning, on our website at fff.org. I know most of you are familiar with the Future of Freedom Foundation. Those that are watching this and getting exposed to FFF for the first time, we were founded in 1989, and our mission is to present the principled, uncompromising case for the libertarian philosophy. And if you come to our website at fff.org, you'll find 31 years of principled articles and books and videos, presentations, conferences, all with the idea of advancing the principled case for the free society. We have a daily email that we strive to make the best commentary page from a libertarian perspective on the internet. It's called FFF Daily. It's free for the asking. We also have a monthly journal called Future of Freedom. We're really especially pleased and honored to have our speaker tonight, Stephen Halbrook. Stephen's certainly one of my heroes in this movement. He's a senior fellow at the Independent Institute. He's taught legal and political philosophy at George Mason University, Howard University, and Tuskegee Institute. He received his JD from Georgetown University Law Center and his PhD in social philosophy from Florida State University. I would certainly say that he's one of the maybe top two scholars on gun rights, especially from a libertarian perspective. He's the author of several books on gun rights and the Second Amendment, including such books as The Right to Bear Arms, Gun Control in Nazi-Occupied France, Gun Control in the Third Reich, The Founder's Second Amendment, That Every Man Be Armed, and my favorite, Target Switzerland, Swiss Armed Neutrality in World War II. He's the author of many articles that have been published in, countless scholarly journals. He's also been published in the mainstream press widely, including the Wall Street Journal, Newsday, the Washington Examiner, Investors Business Daily, and many others. The title of Stephen's talk is The Second Amendment Redux: How Will the Supreme Court Rule This Time? Stephen, thank you for joining us. It's a real honor and a pleasure to have you.
Hey, Jacob. Thank you for having me. Great to be on the show. I'm an old-timey libertarian from college days, and I think my first introduction was I had a Cuban refugee as an economics professor at Florida State University, and he introduced me to Ludwig von Mises, and from there it was a no-brainer. But I'm going to talk about there's a case in the Supreme Court right now that's very important from the perspective of the Second Amendment. By coincidence, 3 months ago, I had a new book came out, and it's called The Right to Bear Arms, a constitutional right of the people or a privilege of the ruling class. And 4 days later, lo and behold, the Supreme Court decided that it would take on a case and review New York State's laws concerning carrying concealed weapons. In other words, the right to bear arms was going to be right before the court. And for a long time, we've been kind of expecting the court might grant review of a case on that topic. Let's start maybe with a few first principles. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. There's two clauses there with two different ideas, although they complement each other. Let's take a look at them. The interesting part about the first clause, the militia clause, is that it declares a principle of political philosophy. A well-regulated militia is necessary to the security of a free state. Now, free state meant a free country. It didn't mean like a state government. James Madison, in fact, when he first drafted what became the Second Amendment, used the term a free country. And the interesting part about that is that it declares a principle, but it doesn't really do a whole lot in and of itself. So you have, it'd be kind of like in the First Amendment, if the First Amendment started with the clause declaring a well-educated public being necessary to the preservation of a free republic. Well, that's a principle, but it doesn't divide power between the federal and the state governments, and it doesn't say anything about the people specifically. So for the Second Amendment, for that issue, you get to the operative clause. The right of the people to keep and bear arms shall not be infringed. Okay, it says the people. I'm guessing that means you and me and everybody else, the general public. The people, that term appears in the First Amendment, the right of the people peaceably to assemble. It's in the Fourth Amendment, the right of the people to be secure in their persons, papers, houses, and effects from unreasonable searches and seizures. So clearly it's an individual right. And what is the right? To keep arms, and that would mean having them in your home and generally possessing and owning them, and bearing arms. Now that seems like a no-brainer. To bear means to carry. So that's what's at issue in this case in New York. Like, do you have a right to bear arms? Can officials declare that only a select number of privileged people have that right? And while we're still on the text of the amendment, what is it that you can keep and bear arms? Well, arms are weapons. We've had a controversy brewing in this country. Actually, there were two basic time periods. For a long time, we had those who wanted to ban handguns. And they would argue that, well, nobody needs handguns. You can have, at one point, they argued you can have sawed-off shotguns, but that the National Firearms Act did away with that. But they would say that, well, you can have rifles and shotguns, so we can ban handguns. So the Supreme Court stepped in, of course, in District of Columbia versus Heller, and said, no, you cannot ban handguns. I'm going to say more about that decision in a minute, but the term arms obviously includes, like the anti-handgun people said for a long time, it includes rifles and shotguns. And yet, what did we start to see beginning in 1989 from California? Bans on certain rifles that are commonly possessed by law-abiding people for lawful purposes, AR-15 rifles. We have just a handful of states, but there's some of the biggest states that ban those rifles. Now, there came a time when I would date it mostly to the 60s, when the argument gained sway that the Second Amendment does not protect the right of any individual to keep and bear arms. You had different variants of the argument, and they were invented basically so that any kind of gun prohibition or criminalization of possessing guns could be upheld. If there's no Second Amendment right for individuals, then you can ban guns and you can prohibit carrying guns. You can do anything you want. So that became a popular theory in the 60s. They called it the collective right model, but it had different variations. One account of it said that states have a right to have militias, and that today is the National Guard. Well, something funny about that argument, none of the people who made that up were fans of the National Guard. And in fact, we had the controversies involving the National Guard in the 60s, where Kent State University, 4 students were shot and killed by National Guardsmen. So the National Guard would not be popular in the ranks of people who made that argument up, but they wanted to contend that individuals don't have any right to keep and bear arms, and therefore all the Second Amendment does is to protect the power of a state to have a National Guard. So there came a time when that argument became unviable. It says the right of the people to keep and bear arms. It doesn't say anything about the militia in that operative clause. So let's get to how can we be creative and invent a new theory under which there's no right of individuals to keep and bear arms. Well, why don't we try to interpose the first clause, the declaratory clause with the militia in it, to restrict the operative clause with that language. So then we have the invention of the idea that, yeah, you have a right to keep and bear arms as an individual, but only in a militia. And the interesting part about that argument is that there's no necessary right to be in a militia. And if you are in a militia, you do what you're told. The militia would have a commanding officer. And if that person tells you peel potatoes, you do that. You don't like carry your Smith & Wesson Model 29 around and say you have a right to bear arms. And so that theory collapsed. And so finally, the Supreme Court stepped in the DC versus Heller case in 2008, an opinion by Justice Scalia. And you have a very thorough analysis of the meaning of the Second Amendment. What the court did was to look at the text, history, and tradition. So the text of the Second Amendment, the people, that's the entity with the right, and it's a right, it's not a state power, and it's to keep and bear arms. The court talked about the term keep, and that means to hold close or to have in the house, and to bear arms, meaning to be able to carry them as a defensive tool. So there's the contrary view, which was in Justice Stevens' dissenting opinion in the Heller case, was that you only have a right to bear arms in the militia. And as we said a minute ago, there's no right even to be in the militia or to do anything that you wish, in particular in a militia. Not to mention that the text of the Second Amendment doesn't refer to the right of the people to bear arms in the militia. It's open-ended. Presumably all lawful purposes would be protected. And it does say should not be infringed. And of course, if you ban the right, that I think would be considered infringement. Now, some have argued that, well, a lot of times in the 18th century, there were references to bearing arms against something, like against the enemy or against the king's forces, things like that. And therefore, it's a militia right only. But there again, the Second Amendment doesn't say anything about bearing arms against somebody or something. It refers to the right to keep and bear arms, and that right shall not be infringed. So where do we go from here? Let's look a little bit more at the Heller case. The District of Columbia banned possession of handguns even in the home. So the decision was that that's invalid under the Second Amendment. You have to have some way to allow people to purchase and to keep handguns minimally in the home. That was the only issue raised in that case, as well as one further issue. Do you have to keep the gun unusable so that you cannot keep it ready for use in case there's a home invasion or robbery or something of that type? And the court invalidated that part of the law as well. So it was a 5-4 decision. Before the case was argued, people were worried about, on both sides, were worried about where's Justice Kennedy gonna go on this case, because he was a swing vote, if you remember, on so many cases. And I'll never forget being in an oral argument, Justice Kennedy's mouth opened and everybody was basically on the edge of their seats, where there's a large lawyer section in the front of the courtroom, and everybody got real attentive when Justice Kennedy's mouth opened. And he asked the lawyer for the District of Columbia, weren't the founders of the country settlers, and didn't they need to have guns for protection against criminals, hostile Indians, and grizzly bears? So two things about that statement. One, it indicated that he thought the Second Amendment protects individual rights. And then the humorous part is there were no grizzly bears east of the Mississippi River. So Justice Kennedy was a Californian, so maybe he didn't know that. Be that as it may, the hopes of the Second Amendment crowd were raised, and those of the antis were lowered, I think, when he spoke. But you never know. You can never read the tea leaves. You can never predict where the Supreme Court's going to go. And I'll never forget being in the courtroom when the decision was announced in June of 2008. What happens when the court announces a decision is the Chief Justice says that so-and-so who wrote the opinion will summarize the decision. And the first decision that the Chief Justice Rehnquist at the time announced would be summarized, he said, would be by Justice Stevens. And we all figured, whoa, if that's the Heller case, we lost. Justice Stevens had a long record of basically being hostile to the interests of the firearms community. But it turned out to be another case, luckily. And when Chief Justice Rehnquist said that Justice Scalia will announce the opinion of the court, we all breathed a sigh of relief. So it was 5-4. There were 2 dissenting opinions, actually. I mentioned Justice Stevens' opinion. There was also a dissenting opinion by Justice Breyer. Justice Breyer took the position that whenever there's a constitutional right, or at least for the Second Amendment, there should be a balancing test. The interests of the government should be balanced with the interests of the individual right. And he pointed to the fact that in 1976, when DC banned handguns, somebody said in the committee report that handguns were dangerous and there were lots of murders. And therefore, a ban on handguns was the appropriate measure. And so based on that legislative history that had no basis, and then some studies on both sides that Justice Breyer didn't take much account of, he would have ruled that under his balancing test, his interest balancing test, that the district should win. So you should be able to ban a constitutional right, in other words, if the government interest is superior to the individual interest. So that means it's no constitutional right at all. Unfortunately, as in the years after that decision, many lower courts have upheld gun bans and gun prohibitions of various kinds based on essentially the same interest balancing test that Justice Breyer in dissent would have enunciated. And they usually call that intermediate scrutiny, these lower courts. So the Heller case resolved that the District of Columbia could not ban handguns. But does the Second Amendment apply to the states? Because obviously it applies to the District of Columbia because that's a federal enclave. Well, it was anticipated that if the court ruled favorably, the next challenge would be the Chicagoland handgun bans. The city of Chicago, Oak Park, Morton Grove, a respectively long list of localities within the vicinity of Chicago, Cook County, banned handguns. And so there were several lawsuits filed against these localities. And the issue then became whether the Second Amendment applied to the states through the 14th Amendment. And that gets us into the history of the adoption of the 14th Amendment. And that history is very important. It's easy to go into the Second Amendment's history and to show that the colonists inherited a right of Englishmen to have arms. It was stated in the English Declaration of Rights of 1689. They had the experience with the British where the British tried to seize their arms. They were intent on keeping their arms, and they fought back with those arms. And so one of the reasons for adoption of the Second Amendment was that the people had experienced the confiscation of arms before, and they wanted to protect against it. So then when we get to the early republic, we have the Second Amendment, but we have one main deficiency in the republic, and that was slavery. And so in the southern states, there were slave codes, and slaves could either not possess guns at all, or in some states, there were laws that they could possess a gun or carry a gun if they got some kind of permit. And that even applied to free blacks in those states. So when the war ended in 1865, the same southern states reenacted the slave codes as the black codes, and they prohibited freed slaves, African Americans, from possession of guns or from carrying guns without a license from the government. And so that led to a lot of controversy, because that was not the only disability or legal disability that was foisted upon African Americans. There were others as well, like you had to have a permit to leave the plantation, or you had to have licenses for this and that different activity that ordinary citizens could freely engage in. So it turned out that one of the reasons for the 14th Amendment being adopted was to get rid of these black codes, so that African Americans could keep and bear arms like everybody else, and could engage in other activities like everybody else, other constitutional rights. So fast forward then to the year 2010, and the Supreme Court heard the case of McDonald versus City of Chicago, and that was the main issue in the case, whether the 14th Amendment incorporated the Second Amendment so that Chicago could not ban handguns. And the court ruled favorably. It was a plurality opinion by Justice Alito. 4 justices total joined in that decision. Justice Thomas wrote a concurring opinion, so that made the 5th vote, allowing there to be 5 votes in favor of invalidating the Chicago handgun ban. So those were the basic precedents on the Second Amendment up until 2010, and then we went into a period in which the court didn't hear any more Second Amendment cases. Meanwhile, lower courts were banning rifles, continuing to restrict various rights. In some states, it made no difference that the Heller and McDonald decisions had been rendered. So I filed a lawsuit, it came to be known as Heller 2, against the District of Columbia restrictions, different kinds of restrictions, but one of the main issues was whether the district could ban rifles that were commonly possessed throughout the United States by law-abiding people, but were called by the propaganda term assault weapons, whether that could survive the Second Amendment, a challenge to the Second Amendment, a challenge under the Second Amendment. And it seemed like a no-brainer because Heller held that the government cannot ban the kinds of arms that are commonly possessed by law-abiding people for lawful purposes. That's why the handgun ban went out the door. But by the same token, the rifles that were banned, they're commonly possessed by law-abiding people for lawful purposes. And we even proved that in the case that, as I said, became known as Heller 2 versus District of Columbia. And we showed that millions and millions of these rifles had been sold, and people had background checks and bought them. And so we ended up with a 2-to-1 adverse decision. The 2 judges voted to uphold the DC ban, and they conceded that these rifles were commonly possessed nationwide. But then the court brought in what it called a balancing or intermediate scrutiny. They didn't call it the balancing test, but it really was that, the same one that Justice Breyer had used. And they said, well, these weapons are evil, wicked, mean, and nasty because somebody in a legislative council meeting said so. For example, there was a Brady Center lobbyist who said, why these rifles, they have a protruding pistol grip, and that makes it designed to fire as many shots as you can from the hip and shoot as many people as possible. And just based on that one ridiculous statement and a couple of other ridiculous statements of that type by people who know nothing about guns, the court in Heller 2 upheld the DC ban on these rifles. But there was a dissenting opinion, and it was by a judge by the name of Brett Kavanaugh. Little did we know that a few years later, he would be elevated to the Supreme Court. And what Judge Kavanaugh would have held was the DC law was invalid. He pointed out that these rifles are possessed nationwide very commonly. The technology has been there 100 years, semi-automatic rifles. Handguns are used on a lot more crimes than these rifles, and yet you cannot ban handguns. And so he faithfully followed the Supreme Court's decision in Heller, and he would have held these bans to be unconstitutional. So that was kind of interesting at the time. That was nice to have a judge dissent, but it never struck anybody that he would end up on the Supreme Court. Then we go into a period in which the Supreme Court didn't hear cases on the Second Amendment. Justice Scalia died, and that left us with kind of a 4-4 vote in the court on a potential Second Amendment case, so it would be unwinnable. But lo and behold, the court rendered a decision called Katano versus Massachusetts out of the blue. And it came from Massachusetts. Massachusetts had a ban on mere possession of stun guns. There was a Ms. Katano who possessed a stun gun for self-protection. She had an abusive ex-boyfriend who had threatened her, perhaps attacked her, and that's why she had the stun gun. And she was caught with it in a parking lot and arrested, prosecuted, and convicted, and the case went to the Supreme Court. But the Supreme Judicial Court of Massachusetts gave some pretty bad reasons for upholding the ban. They said, well, nobody had stun guns in 1791 when the Second Amendment was adopted, and there's no military forces that use them. And therefore, this law is valid under Heller. And the Supreme Court, all 8 justices voting to do this, said, not so fast. This is not what Heller held. You've got to take this case back and look at it again. So the case got remanded back to the Massachusetts High Court. But Justice Alito would have gone further and would have simply stricken out the law, the Massachusetts law, the ban on stun guns as unconstitutional. And he pointed out that this poor woman had been abused. All she was trying to do was protect herself. It's not even a lethal weapon. And it was in poor taste, basically, for the rest of the court to send the case back below instead of just vindicating her on the spot. So the Massachusetts High Court didn't want to make a decision after they had been kind of spanked. And so the prosecution dismissed the charge against her. So it left the law in a limbo. Well, there was further litigation, and finally the law was declared unconstitutional, and there you have it. So then we go into another period in which the court doesn't do much or doesn't do anything on the Second Amendment. There was some activity, though. A case came out of California called Peruta versus San Diego. And the Ninth Circuit Court of Appeals, which has an automatic decision-making process against Second Amendment cases, ruled that a ban on concealed weapons was okay under the Second Amendment, but we're not going to consider whether a ban on open carry is consistent with the Second Amendment. And the Supreme Court denied review of that case. But Justice Thomas wrote a very good dissent from that decision to turn away the case, pointing out that the right to bear arms is right there in the amendment. It's a traditional right. Historically, it's vindicated. And he says, by the way, you know, we accept cases all the time on other constitutional issues involving things that we call constitutional rights that really aren't even in the Constitution. And why are we turning down every case on the Second Amendment now? And so that was repeated itself 2 or 3 other times, with Justice Thomas writing these dissents and Justice Alito joining with him, Justice Gorsuch and others. But the court didn't take another Second Amendment case, though, until a case knocked at the door involving a City of New York law. New York City provides that, let me back up. New York State requires a license to carry a gun, but nobody can get the license unless you show some special need and the government agrees with you. So that means not many people get a license. But even just to have a handgun at home, you have to get a license for that. You know, in most every other state, you just buy the handgun and take it home. You have to have a license, and it's a crime if you don't have a license. So it's a crime to possess a gun in New York, a firearm, which is defined as a pistol or revolver, without a license. So an association and 2 or 3 plaintiffs brought a case. The association was New York State Rifle and Pistol Association. And the individuals made a claim in one instance. I've got a second home in upstate New York. I'd like to take my handgun with me, but the New York City law said you cannot take it out of your house. If you had a premises license for a handgun in New York City, it was like imprisoned in the house. You cannot take it out, other than to go to a shooting range within the city of New York. As you can imagine, there's lots of shooting ranges in the city of New York, like all 5 of them. So another litigant in that case said, I'd like to go to some shooting matches or shooting ranges outside of the city of New York. I mean, that'd be something anybody could do in any other place in the country, just about. And the law said, no, we don't trust you. They got a police expert to say it would be a threat to public safety to allow a person to take the licensed handgun, have it unloaded, locked in the trunk of a car, and to transport it to a shooting range someplace else, or to a second home. And so the Court of Appeals upheld that ridiculous law under that ridiculous reasoning. What was the reasoning? That you might have like road rage and, you know, like, ooh, real danger to public safety to have a unloaded handgun locked in your trunk. But then the Supreme Court took the case. Like the city was frightened, like, we do not want to be here. And they tried every gimmick in the book to get out of the case. They said, oh, we're going to change our ordinance. We're going to make it where you can take your handgun to a second home if you get another license for it from the licensing authority, wherever that is. And you can take it to a shooting range somewhere else, but you have to use only the most direct routes to get there and to come back. So the Supreme Court wouldn't throw the case out before the hearing, but when the hearing came along, New York City, their attorney was saying, oh, this case is moot. There's no case or controversy. We amended the law to give them everything they wanted. And the lawyer was asked them embarrassing questions like, what do you mean the most direct route? Does that mean I can't stop and go to the bathroom or get a cup of coffee or fill up with gas? How about if my mother has a residence somewhere along the way, and can I just stop and visit her for an hour or 2? So there were definitely issues left in the case. Nonetheless, The majority on the court said this case is moot. There's no real controversy left. And so we're going to dismiss the case. Justice Alito, joined by Justice Thomas and Gorsuch, wrote a dissenting opinion. And he said, hey, this case is very much alive. These parties, the New York City, they're manipulating our jurisdiction. They're trying to weasel out of the case by making minor changes that still leave harm to the litigants in this case. And we shouldn't let litigants get away with this. And the court went into, the dissenting opinion rather, went into detail about how under the text of the Second Amendment, you have a right to bear arms, and under our history and tradition, surely you can take your gun out of your home. I mean, look at the way it was at the founding. There were no restrictions of this type whatever. So that was at the end of the, the end of 2020, June of 2020. The case was, the decision was rendered a little bit before that, but then right at the end of the term, the court denied review of all the other Second Amendment cases that were pending before the court. And they were on several different issues, like the right to carry in New Jersey and so-called assault weapons and felons, the extent to which you can ban persons with convictions that are nonviolent, ban possession of firearms for life, things like that. But the court denied review in all those cases. But something happened to change the balance on the court. Justice Ginsburg passed away. Amy Coney Barrett was appointed to the court. Judge Barrett on the Seventh Circuit Court of Appeals had rendered a couple of interesting opinions. One was she questioned the ability to ban possession for a lifetime of a person who's been convicted of a nonviolent crime and is no longer a danger. And she wrote another opinion. That opinion was a dissent in a case, but she wrote another opinion for the court, 3 judges, that it's a violation of the Fourth Amendment just to go doing a search and seizure of an automobile just because the occupants of the automobile had a gun. And she said persons exercising the constitutional right to bear arms shouldn't be subjected to search and seizure when they're engaged in lawful activity. So that decision might be telling as to how she might vote in the case pending before the court. And the case pending before the court is New York State Rifle Pistol and Association versus State of New York, actually versus Bruin, who was the officer in charge of denying permits. The State of New York is the real party in interest. So about 2 months ago, the briefs were filed on behalf of the litigants who challenged the law. And a week ago, the State of New York filed its brief arguing that the law should be upheld. And today, as we speak, there are still amicus briefs in support of New York being filed. If you go to the court's website and find that case, you'll see, I don't know, 40 briefs maybe on behalf of the petitioners, and another 40, maybe who knows how many will come in tonight on behalf of the State of New York. So some interesting things about the way Second Amendment litigation has evolved. Because of Heller, litigants know you have to look at text, history, and tradition. But text is not something that those who ban Second Amendment rights can deal with, because it refers to the right of the people to keep and bear arms, and that right shall not be infringed. In the meantime, there was a case out of the Ninth Circuit, Young versus Hawaii, where the Ninth Circuit said, well, we held before that you can't carry a concealed weapon. Now we're going to say there's no Second Amendment right to openly carry an arm. So that closed the circle. There's no right to open carry and there's no right to concealed carry. So I just noticed that the York brief that was filed a week ago is trying to rely on that decision. But New York has an obligation to look not just at text, and it didn't look at the text at all, but also history and tradition. And what do we have? The chief argument being made by those adverse to the Second Amendment right to carry is that there's a long tradition of restriction that goes back to 1328 and the Statute of Northampton in England. And based on that statute, this was the time of monarchy. It restricted carrying weapons. It was before the age of firearms. That Old English law, medieval English law, has always been a matter of contention, even in England. But we ended up with a judicial decision, Sir John Knight's case in 1686, which held that to violate that old law, you have to carry a gun with evil intent in a manner that terrorizes other people. And so the jury acquitted Sir John Knight in that case because he was carrying arms for self-protection and not aggressively. Nonetheless, the litigants in the New York case and several other cases before that argued that, well, this medieval Statute of Northampton somehow overcomes the explicit language of the Second Amendment, the right to bear arms. And then they go through a long spiel about, well, there's been other restrictions in U.S. history, and in New York, there were really no laws governing the peaceable carrying of arms or handguns included in New York State in the 19th century. There were laws against aggressively carrying guns in ways that terrorized other people, but if you did so peaceably for defensive purposes, that was not a crime. And that only became a crime with the Sullivan Act of 1911. Big Timmy Sullivan was a corrupt politician who got this law passed. He had the Irish gangs working for him. The Italians were immigrating to New York. He was anti-Italian. The interest behind this law was adverse to recent immigrants. And in fact, the first person convicted under the Sullivan Act was an Italian who explained to the judge, I was carrying a gun because I've been threatened by the Black Hand, which was a kind of a pre-mafia criminal gang operating in New York City. So New York, the police weren't protecting this poor fellow. That's why he had a revolver. And the judge chewed him out and said, you're kind, we're going to teach you a lesson. And the New York Times was even more explicit, saying that these Italian people, we got to do something about them with this law. The judge gave the individual 1 year to serve in Sing Sing prison for carrying a revolver for self-defense. So that's been where New York is ever since. It's a statewide law, and it's a felony. And in fact, if you have a loaded handgun, I believe it's 3 years minimum imprisonment, mandatory minimum, and up to 15 years imprisonment, merely for possession of an unlicensed handgun in the state of New York. I mean, you don't get that for voluntary manslaughter. You can kill somebody and the penalty is less. But you go to New York State with an unlicensed handgun, you're liable to do some serious time. So we end up with, if you go back in American history, the only laws on the books in the antebellum period regarding the carrying of arms, it was the concealed weapon prohibitions, mostly in the southern states. Ohio and Indiana also enacted laws like that, but most of the northern states, you could freely carry arms peaceably without any trouble. And then the only other problem, which I mentioned before, was the slave codes. Slaves were not considered citizens. In fact, the Supreme Court said in the Dred Scott case African Americans aren't citizens. And by the way, if you allowed them to be citizens, they could speak freely, and they could keep and carry arms wherever they went. Like, whoa, don't go there. Fortunately, the 13th Amendment abolished slavery, and the 14th Amendment did away with these black codes that prohibited African Americans from carrying guns without a license. That was totally discretionary, somewhat like today's New York licenses. Except that now New York state law has it that it's discretionary as to any person, red, yellow, black, or white. We're going to decide if you have a need to carry a gun, and in most cases we don't think you do, but certain privileged people do. So they get the carry license in, and you live in a high crime area. Hey, tough luck. That's your problem. You can't get the gun license because you're just like everybody else in the high crime area. That's basically a decision by New York state courts that say that. And then there's another issue that's come up in New York. If you Google corruption, New York City gun licensing division, you'll find that people pay bribes to get carry permits, and the police, the friendly police of the gun licensing division, in several cases that were prosecuted, they got money, they got prostitutes, they got traveled to the Caribbean, they got baseball game tickets. Here, you want a license, you pay. And so that's what these discretionary licensing laws make possible. Out in California, you want to give a lot of money to the sheriff's reelection campaign, hey, maybe you get a license. You didn't give any money, well, tough luck. And so that's a very real problem. 44 states nationwide have fair gun carry permit schemes where if you fulfill certain objective requirements, you can get a license to carry a handgun. That means lack of a criminal record. It means that you haven't been committed to a mental institution. It means that if applicable, that you've had the correct training. So that's 44 states. Out of those states, I think it's now 21 that has constitutional carry, where you can carry openly or concealed without any kind of permit or license. I think the majority of states still have open carry, that where you can open carry without any permit. That's been the rule in the United States since colonial times, since the country was settled. So we end up with 6 states of the type of law that is before the court in New York. And it's the usual suspects: California, New Jersey, the states that restrict everything in life, the ones that people are fleeing from. So there's going to be oral argument before the Supreme Court in November. New York State Rifle and Pistol Association versus Bruin. And the court is coming back to the court. They've been doing telephonic arguments up until now, but the only people allowed in the court were going to be the justices and the lawyers arguing the case. And I heard that maybe certain reporters can get in. It's going to be a controversial case. I don't expect there to be a decision until June of 2022. You know, they put off the most controversial cases to the end of the term. I think you'll see very lengthy opinions written by more than one justice. There'll be potentially 6 votes at best in favor of invalidating the New York state law, but you never know. You don't know what can happen. Maybe they'll remand the case for further fact finding. I don't know what good that would do, because we know what the New York law says. You don't get the permit unless you have this special need that nobody else seems to have. So it would really do no good to remand the case. New York state has argued in its brief that if the court rules against us, like, we need to remand the case for further fact finding, but that's just to put things off and to try to avoid a decision. So last time around, when the city of New York case was before the court, there was a half dozen senators who wrote a brief, and they said, "Dear court, we know you're in disarray. If you rule in favor of New York State Rifle and Pistol Association, there's going to be trouble." Senator Whitehouse of Rhode Island was the lead senator in that amicus brief, and it threatened the court. By implication, well, you rule against us or the side that we want to win, there's going to be trouble. We're going to pack the court. I mean, there's any number of things we can do. So I just noticed today there was an amicus brief from, again, some senators in favor of the state of New York, and I haven't had a chance to look at it, but it wouldn't surprise me if it's the same crowd arguing the same thing, like threatening the court. And what's really bizarre about that, Senator Whitehouse is a member of the bar of the Supreme Court. He's a lawyer, and to make arguments of that type when you're a member of the bar, whoa, that's pretty incredible. So I've been I'm always afraid I'm going to go over, and I can never tell time with my watch. So I have my trusty stopwatch, and I just noticed I had about a minute left to the time I was thinking about speaking. So I think what I'm going to do is mention my book one more time, The Right to Bear Arms, a Constitutional Right of the People, or a Privilege of the Ruling Class. And I'll close my formal remarks there. And maybe perhaps Jacob might have comments now, and those in the audience might have questions.
Okay, thank you, Stephen. Absolutely excellent presentation. Let me start out with a question that you mentioned New York, and I've traveled to New Hampshire a number of times in my car. What does a person do that's got a concealed carry permit here in Virginia and they have no restrictions in New Hampshire when he's traveling through New York? What's the law on that type of thing?
Well, if they catch you, they'll charge you with the felony of having an unlicensed handgun. We have a federal law that's supposed to allow you to just pass through. And what it says is that a person is entitled to transport a gun from one place where it's legal to another place where it's legal, through an area where it's not legal, and to be unmolested, as long as it's unloaded and like in the car trunk and it's not accessible. A Virginia permit won't do you any good at all in New York. They don't give temporary permits to outsiders, like we're foreigners or something. So it's a crime. The best thing is to avoid the state if you can, and if you cannot, like, just don't get stopped. Make sure your tail gate light is working. And for everything you do, don't go through LaGuardia or Kennedy Airport and think you can check your gun and with your checked baggage like you can anywhere else in the country. They're going to call the police. You're going to be put in the slammer. So they're basically nullifying the federal law, the pass-through law.
Now, what happened to that woman that was caught there at LaGuardia a few years ago with her handgun, and she had a concealed carry permit from some other state? Do you recall that?
There's been several cases I'm familiar with, and I litigated a civil case where there was a lawyer flying, I think, from Jersey to Florida, and he went through the airport and they busted him, and he showed them the federal law and didn't make any difference. In fact, the cop said, "This is New York, federal law doesn't apply here." But what you do, you get a lawyer, and they will most likely dismiss the case because they know they can't beat the federal law, but they'll arrest you anyway. So I hope the lady got a lawyer, the one that you referred to.
Okay. One question is, how do the gun rights opponents define the terms keep and bear arms? The opponents of gun rights, how do they define those terms?
Well, they'll try to say anything to weasel out of the plain meaning. So there was one, I'm trying to think which Ivy League school he's a law professor in. He said, well, keep and bear is kind of like cruel and unusual. Those terms go together, and it's really just a militia right. They try to concoct theories that are, not linguistically correct. They try to say bear arms means only in the militia. That's the latest. That's the biggest fad, is to say that. Or they might say, yeah, you have a right to bear arms. And in the New York case, New York City state rather argues, well, they can bear arms when they go to the shooting range or go hunting. The license allows them to do that. They just can't do it for self-defense. So the language is what gets them.
Okay, here's another question. What is your opinion of congressionally legislated national reciprocity for concealed carry licenses? I like the ends, but it seems to me to be an affront to the Constitution by violating the federal system. What do you think?
Well, there's different constitutional theories that would be considered for such an enactment. Keep this in mind. The Federal Gun Control Act, what is the constitutional basis of that? The Title I, the Gun Control Act, that's the part that applies to like normal guns, was passed under the so-called interstate commerce power of Congress. Congress can regulate interstate commerce, and therefore, for example, they can regulate gun businesses because they engage in interstate commerce. They can regulate felon possession of guns if the gun has passed across state lines. And so there's a commerce theory to most of the Gun Control Act. And then if you get to the National Firearms Act regulating short barrel rifles and silencers, things like that, that's part of the Internal Revenue Code. So Congress says we can regulate that because we're taxing these guns, and therefore we require them to be registered to show who's paid the tax. So if you use the same jurisdictional hooks that Congress used for that, you could say we're regulating interstate commerce when we say licenses should be subject to reciprocity between states because people travel interstate. So you could make that argument and it'd be just as strong as the argument that the rest of the Gun Control Act is based on. Or you could make a Second Amendment argument in that favor. Congress has power to enforce the 14th Amendment. The Second Amendment is incorporated into the Second Amendment. And so states that don't allow outsiders, kind of like illegal immigrants, I'm going to call them. If you're from Virginia and you want to go through New York, they don't care if you're from who knows where in the world, but if you're from Virginia, we're going to pop you. We don't consider you to be a citizen. At any rate, you could make an argument that might stand up in court, and I won't make predictions though, that to enforce Second Amendment rights, states have to recognize the valid handgun carry permits of other states.
Okay, next question. Why don't gun license requirements themselves violate the Second Amendment?
Well, if you go to just the original history, there were no gun licenses required at the founding in America. If you go back to medieval English history, during the more absolute monarchical reigns, Henry VIII, people like that, there were some laws where you had to get the king's license to have a gun or to carry a gun, which you couldn't get unless you had a certain amount of wealth. So licensing requirements started up when some states began to ban the carrying of guns in basically the turn of the century, from the 19th to the 20th. And it became an issue that you had to be carrying a gun for self-defense or other legitimate purpose, and that you never knew if you were going to be convicted under a law like that. And so during the 1980s, these shall issue licensing laws started to be passed in Florida, and then it spread to other states. Now it's in 44 states. So I can't give you a complete vindication of why licensing requirements are valid. And in fact, those states that now have constitutional carry, that's why they've enacted those laws. You can carry unlicensed in 21 or so states now.
Well, and Texas has a concealed carry permit that's kind of been made moot recently, right? By virtue of the fact that I think they have open carry. I mean, you don't need licensing at all for concealed carry there anymore.
Right, but the license is useful if you go to another state.
Okay.
Because most states do have reciprocity. Most states recognize other out-of-state licenses.
Oh, that's a great point. So you're still in your interest to get the license in Texas.
Yeah, that's why a lot of people get a Utah license. You don't have to live there, or Florida. You can get it as an out-of-state person, and then it's good in lots of states.
Uh-huh. Okay, here's the one that's type of question is it late night libertarian conventions when people are sitting around the campfire figuring out what to argue about. Can one legally or under the Second Amendment carry an atomic bomb with him?
Nope. So let's look at the words of the Second Amendment. Keep and bear arms. You don't carry an atomic bomb. I assume they're big and heavy. And also there's certain, and here's the thing about questions like that. So frequently we hear the argument that, oh, you say you can carry a gun. Well, that means bazookas for everybody and machine guns at the schools and everything. But nobody's arguing for that. What we're arguing for, carrying rifles, pistols, shotguns lawfully, peaceably. That's what this issue is all about. Nobody's saying they want to carry a bazooka, which is obsolete anyway. And then I can make an ethical argument too for the fact that small arms, of projectile arms, allow you to distinguish good guys and bad guys. So if you are attacked by somebody, you can aim and shoot the bad guy, but you're not going to shoot innocent bystanders. That's why grenades, you can argue grenades aren't constitutionally protected because they just kill everybody who's there. But once again, these are kind of hypotheticals, and you're right. This is like the libertarian late night campfire question, because that's not what the issue is all about. The issue, like right now, is whether you can carry a handgun in New York consistent with the right to bear arms.
Right. Okay. Final question is going to be my personal question. And can you talk a little bit about the Swiss model of gun ownership and defense, and maybe go a little bit into World War II?
Yeah, I've written 2 books. One is Target Switzerland. One is The Swiss and the Nazis. And they go into great detail about the traditional militia in Switzerland. Traditionally, Switzerland was a country that our founders looked up to because they had no monarchy, and yet they defeated the big powers in Europe. The Habsburgs, the French, everybody who tried to conquer them, they regretted it. Things were very bloody in many of the big battles, and sometimes all the Swiss would get killed, but they killed so many of the others that they never wanted to come back. And so that long tradition of arming yourself and being every able-bodied man was obliged to provide his own arms, going back at least to medieval times. And so when we come up to the modern age, Switzerland had, during the 19th century, their constitution provided that when every male becomes of age, he's presented with an arm, and the law was that he would keep it. And that exists to this very day, that those who go into the militia army can keep their arms permanently. But the Swiss militia army, they don't have a regular standing army, was the largest in World War II, when they were threatened on all sides by the Axis powers, Germany, Nazi Germany particularly, but fascist Italy as well. They had up to 850,000 people under arms, either as militia, in active service, or as what they call Ortswehr, the like local defense. These would be boys and old men. They were armed as well. And but because of that armed society, you had the armed populace as well as the defensive Alps. When Nazi Germany decided to invade France, they went in the northerly route through Benelux. You know, they went through Belgium, Luxembourg, Netherlands, and they avoided the southerly route, which would have been through Switzerland because of the defenses there. And so this long militia tradition has endured, although there's you know, things are changing in Europe. Unfortunately, Switzerland is not in the EU, but it's part of the Schengen Accord, and the EU is imposing gun restrictions like never before. And so there have been restrictions, newly imposed restrictions in Switzerland that never existed before, but it's still very very free, and not just relatively free. There are shooting matches all over the country throughout the year, and it's not unusual to see people on a tram or, you know, a motorcycle or on a train with guns because they're going to a shooting match. I mean, they carry rifles on their shoulders. They don't even put them in cases. So it's an armed society still. There are intrusions, and it's because of this growing European Union menace, I'll call it that. The Eastern European countries are rebelling against that somewhat. Czech Republic, Hungary, Poland. The EU has this, you know, this universalist imposition, this message that we're going to become one of these, you know, international societies, and anything goes, and anybody can come in and can change the traditions in the country. So, but Switzerland is still enduring. Like all countries, this COVID stuff is making inroads in individual liberties, and we'll see what happens with that. But you know, Switzerland's had a very long tradition of an armed society, unlike no other country in Europe. The other countries have always been more restrictive, and it's one of the most largest number of gun ownership countries in the world.
Okay, well, we got one final question. It is a very personal nature. You don't have to answer it, but I feel compelled to bring it up. Would Mr. Halbrook consider shaving his mustache? He looks good with it, but he would look irresistibly more handsome without it. So there you go.
You know, I tried to talk my wife and children into that, and they said no. So I gave up. I'm willing to do it, not a problem.
Okay, so there you have his answer, Kate.
Yeah.
Steve, thank you very much. That's a fantastic presentation. We couldn't have asked for more. I personally consider the right to keep and bear arms the most important civil liberty. I think they should have made it the First Amendment rather than the Second Amendment. But thank you. Excellent presentation.
Well, thank you for having me, Jacob, and thank you for the work that your foundation does. I mean, I've looked at the other speakers you've had and your website, and you're doing great work, and just keep it up, man. This is wonderful.
Well, thank you. That's quite nice to get your compliment on that. Next week, we got James Bovart's going to be talking about the 20-year post 9/11 war on liberty. You don't want to miss that. Jim's always entertaining and informative, and we're going to have a good time talking with him. He's been writing for the Future of Freedom Foundation practically the entire 31 years of our existence. So it'll be nice to have him. So again, thank you, Steve, and we'll look forward to seeing y'all next week.
Okay, Jacob. Yeah, take care, man. Good night.
Good night.